Sedition became a buzzword after the Kanhaiya controversy in New Delhi in India. What is sedition? It is a deadly word that every Indian should know more about. Let's begin with the first question. What is sedition and what it is not? Sedition has been defined as an offence under the Indian Penal Code and is punishable with imprisonment up to 3 years or fine or both. It has been defined legally under Section 124A of the Indian Penal Code, which defines what sedition is. As per the legal definition, Section 124 of Indian Penal Code lays down that whoever by words, either spoken or written, or by signs, or by visible representation or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law in India shall be punishable for the offence of sedition. The explanation lays down that disaffection includes disloyalty and all feelings of enmity. However, it clarifies that any comments expressing disapprobation of the measures of the government with a view to obtain their alteration by lawful means without exciting or attempting to excite hatred, contempt, or disaffection does not constitute an offence under this section. It similarly lays down that any comments expressing disapprobation of the administrative or other action of the government without exciting or attempting to excite hatred, contempt, or disaffection do not constitute an offence under this section. The question that arises is that if this is the definition, how is it interpreted? And unfortunately, sedition is one law which is much abused in India. It dates back to a long time, during the time of the Britishers, where the Britishers used the law of sedition against several freedom fighters. Sedition first became part of the Indian Penal Code in the year 1870. The Britishers used sedition to crush the freedom movement in India. Many freedom fighters were imprisoned abusing the law of sedition. Most notably, in the year 1897, Bal Gangadhar Tilak was imprisoned under the law of sedition for a speech he made. Similarly, in the year 1922, Mohandas Karamchand Gandhi was punished for the articles he wrote in Young India. Gandhi said, in quote, "Section 124A, under which I am happily charged, is perhaps the prince among the political sections of the Indian Penal Code designed to suppress the liberty of the citizen." In the same vein, Nehru in Parliament in the year 1951 said, "Section 124A is highly objectionable and obnoxious, and it should have no place, both for practical and historical reasons, if you like, in any body of law that we might pass. The sooner we get rid of it, the better." So how do we see sedition vis-a-vis the Constitution of India? In the Indian Constitution, the freedom of speech and expression is a fundamental right under Article 19(1)(a). Does Section 124A of the Indian Penal Code violate Article 19(1)(a) of the Indian Constitution? This question came up before the Indian Supreme Court in the year 1962 in Kedarnath case. In the Kedarnath case, the Supreme Court held that Article 19(1)(a) can be restricted on the ground of order. But the court explained what amounts to sedition. The Supreme Court laid down comments, however strongly worded, without exciting those feelings which generate the inclination to cause public disorder by acts of violence would not be penal. In other words, for sedition, there should be violence. Creating hatred, contempt, disaffection towards the government by resorting to violent means amount to sedition. So would the criticism of the government and sloganeering amount to sedition? No. Will the criticism of administrative and other actions of the government be sedition? No. In September 2016, the Supreme Court once again considered the issue of sedition in a petition filed by the NGO Common Cause. The Supreme Court once again said, someone making a statement to criticize the government does not invoke an offense under sedition or defamation law. We have made it clear that invoking of Section 124A of Indian Penal Code requires that certain guidelines should be followed as per the earlier judgment, which is the Kedarnath case. So remember, in an open democracy, criticizing the government or expressing your opinion does not amount to sedition.